secure, and safely protected. The more valuable something is, the more carefully we need to protect it. Personal privacy is one of the most valued rights of living in our society. But we're also living in the information age. The more advanced and efficient our technology for record-keeping gets, the more things we can do with the information, and the more valuable that information becomes.
Ontario's new Freedom of Information and Protection of Individual Privacy Act formally recognizes the value of personal information and is designed to protect it. The legislation does this in two important ways. First, it sets the standards for the collection, the use, and the disclosure of personal information by government ministries and agencies. And second, it gives us the right of access to our own personal information. We can even request corrections to our records should they be inaccurate.
Throughout our lives, personal information is collected from us and stored by government ministries, agencies, crown corporations, and other government bodies. This information may include our name, address, our financial status, national or ethnic origin, marital status, educational, medical, and employment history, reference letters about us, and even personal opinions. As individuals, we want our privacy securely guarded. We want to know the nature of the information collected about us, how and why it's being used, and who uses it. And we want to know that it's accurate. The new Freedom of Information and Protection of Individual Privacy Act is simply the legislation of these basic, fair expectations. Now, as managers of personal information, we're in a key position of responsibility. We have a crucial role to play in seeing that our new privacy rights are upheld. But all the Act really requires is that we handle the personal information of others as we'd expect our own to be handled.
This presentation has been prepared to outline the privacy protection requirements of the Act and the procedures they entail. Above all, we have to think in a new way about the personal information that we collect, use, and disclose to others in our daily work.
To begin with, there may be some changes in the sort of information we're allowed to collect and in the manner of collection. The Act allows us to collect only that personal information which is necessary to the operation of a particular program or activity. It's important to remember that this includes the verbal collection of information. For instance, the collection of personal information through a telephone interview. As a general rule, personal information must be collected directly from, or with the consent of, the person to whom it relates. There are a few exceptions to this rule, but they are limited to the specific provisions in the legislation.
When information is collected about an individual, he or she must be made aware of the authority for the collection and the intended use of the information. And in case any questions or concerns arise, the individual must be provided with the title, the business address, and the telephone number of a contact person within your ministry or agency. And in most cases, thank you, this notification can simply be added to the form used to collect the information. Once personal information is collected, it's normally organized and stored in a manner that makes it easy to retrieve, whether it be in a computer database or a filing system.
When the personal information is part of an organized collection and can be retrieved using a personal identifier, such as a name or a social insurance number, the Act refers to this collection as a personal information bank.
Each personal information bank under the custody or control of a ministry or agency must be listed in the Directory of Personal Information Banks. The directory helps to ensure the accountability with respect to the collection, use, disclosure, and management of personal information.
For each personal information bank, it provides a description of the types of information maintained, how the information is used, and to whom it may be disclosed. The Freedom of Information Coordinator at each ministry or agency ensures that the Directory of Personal Information Banks is complete and up to date. To assist the public in locating and accessing their records, the directory is available in libraries and Ontario government offices across the province.
The general rule is that personal information may be used or disclosed only for the purpose for which it was obtained, or for a consistent purpose. Now, consistent purpose means that the individual might reasonably have anticipated the use or disclosure at the time the information was collected.
For example, an employee would expect that information collected at the time of hiring might also be used by payroll to issue a paycheck. Of course, use or disclosure of personal information is also permitted where the individual consents to it. There are a number of other exceptions, but again, they're limited to the provisions specified in the legislation.
One very important thing to remember is that individuals have a right to know how their personal information is being used and to whom it's being disclosed. Most of the time, that's a simple matter, as you'll be using or disclosing information as listed in the directory. There will be some instances, however, where personal information is used or disclosed for a purpose not listed in the directory.
When this happens, a record of use or disclosure must be linked to the personal information. In effect, this attachment becomes part of the record itself and must appear when the record is accessed. The record of use should specify what information was used, for what purpose, and by whom.
In some cases, a one-time use or disclosure will become regular and ongoing. When this happens, contact your Freedom of Information coordinator so that the new use or disclosure is included in an update of the directory. But remember, the new use must be consistent with the purpose for which the information was obtained.
Maintaining an accurate record of use will also become important when an individual makes a request under the Act for a correction to his or her personal information. If a correction is made, every person who has had access to the information over the previous year must be notified, should the individual request it.
Secure maintenance and handling procedures are required to ensure the confidentiality of the information in our custody.
All information must be strictly protected, whether it be with a confidential computer access code or a locked file cabinet. Implementing our new rights presents all of us with a challenge. But remember, if you have any questions or need help, your Freedom of Information coordinator will be on hand to assist you.
The Freedom of Information and Protection of Individual Privacy Act. Let's make it work for all of us.